Hey, welcome back. So the legal aspects of inspections, searches and seizures. Um, Very important part of the program. Uh, there is a video that I think I sent you via email. If not, I'll resend that to you. For some reason, it won't play on here. Well, it plays, but I can't get the volume, the audio. So at any rate, it's basically just giving you the same narrative that that we'll be presenting here in the course. Uh, the attorney Will Willis, I knew him up in Albany. It's kind of an older video. He's long retired, but he, it's just emphasizing the importance of, some of you who are not going to be code enforcement people, but it's good advice for yourselves as well. It gives you some case law. It gives you some background in how things are, how the civil rights and things like that should be protected. Certainly, we have no authority to violate anybody's civil rights in this job. So it's important that goes with everything from how you inspect, how you approach people, what you're allowed to do and what you're not allowed to do. And remember, it's what may be simple and easy for you may rub someone else the wrong way. So always be careful. Like I said before, and I'll say it again, don't bring up, anything about your favorite sports team or anything like that, religion, politics, or whatnot. Try to be just, calm and collective as you can throughout this job. So describe the authority for inspection and the rights to privacy. List acceptable methods of entry into property. Very important. You don't want to be trespassing. Certainly don't want to be accused of trespassing. Describe the consequences of an improper inspection. So the authority, many local ordinances have a refuse to allow inspection clause, and we're going to explain how that's not going to work. Authorizes the code official to conduct inspections determined to be in conflict with constitutional rights. Basically, these are, they've held these, for many years. Back in 1959, this was a, some sort of the health department was involved with some, or the housing inspectors were involved with some rat complaint, vermin complaint. This is a very famous case where the person, Frank versus Maryland, the state of Maryland, would not consent to an inspection. The fine was fined $20 for his refusal. Appealed to the Supreme Court, and basically said that warrantless search is constitutional for administrative purposes. So allowed the fine or refusal to allow the inspection. So that's where the court went on that. However, Frank appealed to the U.S. Supreme Court, and it said that that the Fourth Amendment and the 14th Amendments, the individual rights to privacy and due process, and the Supreme Court did not view the administrative actions as rising to the level as criminal action. The criminal action is, is where you have a warrant and you have these kind of things, and we'll explain some of this exigent circumstances and things like that. But for the most part, it's you can't violate someone's constitutional rights with regard to you know, inspections and so on. So the police powers of the municipality is restricted by the Constitution. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath of affirmation and particularly describing the place to be searched and the things to be searched and seized. Code enforcement subject to balance of power, municipality versus the power to enforce the codes, protect the, basically protect the health and safety, the welfare. But the Fourth Amendment, right, and the right to privacy and free from unlawful searches and seizures. It's very simple, and the New York State Constitution is kind of, is similar. Statute cannot authorize a warrantless search. This is what came out of the Camaro versus San Francisco, C versus Seattle. It says the decision in these cases was privacy does not apply to public areas. Administrative code should have same protection as criminal statute. You need a valid search warrant from a judicial officer showing probable cause. If you have, probable cause to indicate that there's some sort of code violation in some building, you need to have an affidavit signed and then get that signed by the judge for that type of activity. I would suggest seriously consider all of that with your town attorney and counsel. Don't try to do this on your own. It's not going to work. So the right to privacy, the consent has to be, it really needs to be clear, right? The person, you come to the door, you show your badge or whatever, you can't really intimidate or anything like that, right? So you need to get that from the get-go. And then the search warrant and exigent circumstances, they're in an emergency, and we'll explain that as well. So the valid consent is, who's got the privacy interests in this place? If you go to an apartment building and you need to go inspect something, and it's just a guest in the apartment, they don't have the authority to allow you in to look or search or do anything. So it has to be someone with the privacy rights to lose, and that means the tenant who pays the rent. And by the way, there's case law out there that even if they're renting and for free, it's implied that they have the privacy rights to this place. So if you let someone stay in your apartment for free, they basically have the rights to that privacy. And then, so the consent has to be given freely. No one can coerce them to say, to scare them into doing that. And then informed, right? It's, you're telling them what they're doing. And then competent. Are they competent? Can these folks, maybe they don't speak English, maybe they're mentally unstable or something like that. So it has to be pretty clear. The inspector may have to use his or her judgment. And I would say my personal approach to all of this is always, every space I went into, I would say, is it okay if I go in there? Is it okay if I go in there? Even if I had consent to go through the whole place, just ask the question. It does not hurt. And it shows respect. And if I've had a feeling that these people weren't competent or whatnot, certainly if there's a young child there, you don't go in that place. They're by themselves, or in my case, I never went in a place where a woman was by themselves. It just doesn't, you don't need that kind of aggravation. So just be careful and make sure that, people understand what you're saying. The test for valid consent. Maybe the only granted by the person who has the lawful privacy to lose in this place, right? The owner, by the way, is not the owner, even though they own the building. They don't have the privacy rights to that place. The owner can't say, I allowed you to go in, and I'm letting that tenant better let you in. That's not how that works. So that they only consent to those areas exclusively under his or her control of the interest. So if it's a commercial building, the owner and it's the landlord can certainly escort you into the areas that are common areas, whether it's the laundry room, the boiler rooms, common hallways, attics, basements, grounds outside, whatever the case might be. But each apartment where they have a key, even if it's not locked, and that's clearly their place. I've been on thousands of inspections, and I've had several places we've gotten to with the building managers, and we show up, and even though they had notices for the last 3 days that fire safety inspections were being conducted on this such and such a date, and there were several who we got to the door and they just said, I don't want anybody coming in. I just looked at the building manager and my whole team, and we just go to the next place. You didn't get in an argument with them, and we left it up to the building manager to gain access there because they have an authority to do in for regular routine maintenance and stuff like that. So we left it to them to do that. If we were very concerned that there was we had no reason to believe that there was any, nefarious activity going on. So we weren't going to go file for a warrant or anything. It wouldn't have been worth it. Remember, all of this stuff costs you municipality time, money, public relations, all of that type of thing. So you'll learn that as you go. Valid consent given freely. Threats you can't, must be voluntarily given and not result under duress, coercion. The Supreme Court has stated that whether or not consent is to be considered voluntarily is a question to be determined from all the circumstances of the situation. Some factors in the court will likely consider whether the police, the CEO, code enforcement person employed threats or other coercive techniques, right? How to frown on their face. Whether the individual knew he could refuse. Do they know that they can say no? They not. The person may intimidate them so much that they're afraid to do that. Whether the individual is accustomed to dealing with the police or other government agencies. Whether individuals is in custody at the time consent is given. Whether prior to giving consent the individual has been evasive or uncooperative with the police. None of these factors are to be considered controlling, but they are factors which a court is likely to examine when determining, if somebody's, voluntarily consented to a search or not. And remember, you're a government official, an agent for the town. You wear a hat and you have a title, so you need to be very careful of how you deal with that. Clear and convincing and positive. Was consent clearly stated? Did the individual unduly hesitate? Failure to deny the inspection is not the same as giving positive consent. So if they're, mind if I come in? I'll just take a minute. No, I do not consent to your entering or searching. That's pretty clear to me. And at that point, what do? Well, if you look at that video, you don't threaten this person. You just you say thank you very much. You leave and you go to the next level, whatever you may do. Okay. Individual granting consent must be competent to do so. Factors are considered in determining the age of a young child, even though a lawful occupant could not give the consent. The mental capacity, does the individual, have the capacity to determine the implication of the request? Do they understand what you're actually asking them to do? Does the individual comprehend? Is there a language barrier, as we said, all of these things. you know, if they refuse, then you can, you know, go for, you know, seek a search warrant, and you know, it has to be, you know, pretty clear. You know, the probable cause. There's only one search warrant. When used for administrative purposes such as code enforcement, the standard for probable cause may not be as strict as it would be for criminal prosecution. So code enforcement is a little, as we mentioned earlier, I think we mentioned earlier, code enforcement is your main objective is to get voluntary compliance. You're not police personnel. You're not here to put people in jail. You want voluntary compliance. It makes things go much smoother, much easier, and less headache. Absent that, you know, you might have to get a warrant, but for the most part, it's not criminal. What they did or what they have done, they've done, you know, they built without a permit, or they did something, you know, doing something, building inside without a permit, then you know, you just, you know, basically work with them and say, look, can we get this under control? File for a permit, we're good to go. On the flip side, the police action, by the way, voluntary compliance, if they abate the problem, you're good to go, right? Everybody knows that. In criminal activity, let's just say the person's, you know, robs, you know, a nail gun from the local hardware store and goes running out to the parking lot, and the police catch him. The people call or whatever, the security catches them. You know, voluntary compliance there is not, well, if I put the nail gun back, will you let me go? That's not how that works. They have to, you know, they have to face the music and the time or whatever punishment. In your world, the code world, we just want the issue abated. We want buildings safe. That's all there is to it. Probable cause, it was developed in criminal investigations standard. It does not have to be as strict for code compliance as it does for, you know, you're filing probable cause to go in and actually, you know, arrest someone for whatever the case might be. You have reason to suspect there's, you know, crystal methamphetamine factory inside the people's building. You know, that has to be pretty clear. You got to have pretty good evidence to that, you know, to support that. With, you know, with when it comes to code enforcement, you know, could have been, you know, the condition of neighborhoods all run down, the nature of the buildings, you know, the passage of time, and that type of thing. So, you know, you know, if you're going to file for a warrant, make sure that you have, you know, probable cause, and that could be, you know, any type of thing. Even in your probable cause also comes, you can get affidavits from the neighbors, and then we're going to explain how you can utilize the neighbors to help you, and because that's where the complaints will be coming from anyway. Request made to local court, you know, this simply gets, you know, filed with the court. You must show that evidence of an offense is present at the property. You must have some idea. The judge will make a determination if there's probable cause based on the totality of the circumstances. The information is not hearsay in nature, so they need some more than just hearsay. The neighbor doesn't like the other neighbor, and that type of thing. Because when you file for a search warrant, it's called a takings, right? We have a very protective of those rights in the United States, New York State. You know, we don't want anybody, you know, violating our rights to privacy. So you know, we don't want everybody barging in here in your home or in your wherever you are. So has to be pretty clear. Demonstrate an offense was committed. You know, they built without a permit. Somebody found that, or that type of thing. You see, someone's got pictures of trucks, dropping off 50 sheets of sheetrock or 2x4s or whatever. Then the application for the warrant has to have the heading: the inspector, identity, the property, search for what, right? What are we doing here? Why are we here? Deposition. What's the probable cause? Who are you? The history and details of property owner, background, prepare a sample, and you should be able to have one right at the court in your jurisdiction now that you can copy and paste from and utilize the same thing, just change the names probably. But the contents of the designated premises description must be complete, including the apartment number, floor, position relative to other premises in the building. It's got to be very clear, right? Because you're only going to this one place. You have to be specific as to what you're going there for. These people wouldn't let you in. You're doing the fire safety inspection. You have reason to believe, blah blah blah. And but it has to be pretty clear, and then submit it to the judge, and the judge will either sign it or deny it. And the property fits into one of the 4 categories of property that can be seized, right? Must be, it must have, you must have some sort of reason why you have to violate these people's rights to go in, and and they're going to weigh public safety aspect, that you think there's a boiler heating system that's in there unsafe and people are going to die, or that type of thing, whatever the case might be. Must be executed by a police officer. Inspectors allowed to accompany that officer, and it can only be done between 6 a.m. and 9 p.m. unless it contains a nighttime endorsement, and that's going to be typically a criminal, more of a criminal thing. The owner need not be present. Officers must make a reasonable effort to give notice of authority and purpose to the occupants. Must show warrant on request. Identifies the property and what can be searched for. Search can only be conducted in those areas where the object is discussed, whether it's a warrant for they built the apartment in a garage, or they have a heating system that was not vented or something like that. They go to the basement, and allows forcible, and property must be returned to the original condition, repair, replace locks, leaves. If they've forcible entry and they break the door down, and they have to it's supposed to be repaired back to the way it was. Warrant is carried out by the police officer and must be returned to the court by the officer without unnecessary delay. Basically, should be ASAP. List the evidence that you found or seized or whatever, written inventory, subscribed and sworn by the officer. The more information, the better. Right? Be very clear. So you're going to have to work with the police department to execute these warrants. You'll be there. The one associated with this, the one that started it. So you have to be there to finish it. And then forbids unreasonable searches and seizures. Right? If the if you don't have all of this stuff here, then you're not going to be able to execute, effectively and win in the court. Don't forget, these people are going to be have somebody defending them, and you have to be able to stand on the that you did this properly and within the confines of the orders and so on. You can only seize the stuff that's on the warrant. You can't go any further than that. Can't go walking in, and if you're concerned about a boiler, illegal boiler or something like that, you can't go waltzing around through all the rooms in the house or the building. Acceptable searches, plain view, lawfully allowed to be there. Inspector may look into any area where the owner does not have a reasonable expectation of privacy. It does not include jumping up to a window, looking at the property from the sidewalk. Looking at the property from the sidewalk is acceptable. Here's one of my rules of thumb, and it's always worked well for us. They say the front door, the door is usually the place of business. That's where the mail person would come. That's where the deliveries would be done. That's where anybody asking directions would knock on that person's main door. That would be, in my opinion, okay. Now, if there's a gate to open up before you get to that main door, I'd say don't go past that. Never go behind the building. This could be somebody back there in the swimming pool or whatever. So be very cautious about walking around the back, especially if you're unattended. I wouldn't advise it. Consent must be voluntary and intelligent. They do not have to know that they have a right to refuse the inspection per se, but you have to make it clear that you're just there to look at this or that and type of thing. The age of the person, it's basically should be, anybody 16 and under will not work. Coercion or threats, that's not going to help. From another property, if someone asks you, for the most part, the complaint's going to come in from next door anyway. So just say, can I go over there and look from your yard to see if there's a pool's been put in without a permit? And courts have said that's acceptable. I would be a little cautious about jumping up to look over a fence, but if you can get a clear view from the neighboring property with their consent to go on their land, by the way, again, they're probably the people who are going to make the initial complaint to begin with. Intimidation or trespassing, threatening or promising the person will receive a summons if you don't let me in. Conducting search from a place where you're not lawfully allowed will invalidate the search and may also get you in additional trouble. So don't violate anybody's civil rights. Again, private property. We live in America. People are very protective of their privacy rights, as you all are, and I'm sure your people are. You don't want to see some official walking up your, coming out of the backwoods or whatever. And identify yourself, have your ID out, ask specifically for the consent, advise the occupant what you're there to inspect. Say, well, you understand whether, if it's just like, well, we understand there might be a work being done without a permit, whatever the case might be, but be pretty clear. Advise the occupant of the consequences. Well, I just want to clear this up, and if I can't, we might have to go further, et cetera, et cetera. And you must, the consent must be clear and convincing. It can't just be someone mumbling. Exigent circumstances. 3 elements must be present. Serious threat to life, so imminent the delay for a warrant would harm someone. Could result in serious physical damage, that type of thing. A rare occurrence. But what if there was, toxic waste or something there, and that type of thing, right? So all of the above elements must be present at the time. But that means, you don't just go charging into someone's property. Basically, it should be something very, very, very unsafe. Okay. All right, so let's take a little break, come back at 10 o'clock. Okay, personal and professional attributes of code enforcement. So what are the most important qualities of code enforcement? Integrity, knowledge, image, communication, being fair, firm, that type of thing. Consistent. Just be consistent with however you operate your department. And if you are dealing with your constituency, then certainly, be as clear, and concise and respectful as you are with anyone, equally. So, how would you feel if you're dealing with a code person? What's the public impression? Argumentative or knowledgeable? They take on many different, attributes. I've heard the good, the bad, and the ugly throughout this entire state. Some are very, very good. Some are effective. Some are ineffective. The minute you become argumentative and whatnot, people will just start going underground and not deal with you at all. So, don't use don't use your title or your authority in a demeaning way. Okay? And who do you communicate with? How and why? Are you a good communicator? Some of us are, some of us aren't. You got to deal with contractors, builders, architects, complaints, property owners, elected officials, supervisors, work staff, county officials. Other examples of cooperation are from the DEC and the Army Corps. Are they going to be people that you can communicate with? And again, you can be fair but firm. Just make sure that that you're doing your job as best you can. Back and forth. What's the what do these people want? Why are they contacting you? Who's involved? What do they want you to do? Right. Basically, in your world, it's going to be, they want you to either respond to a complaint, or they want you to review a set of plans, or issue a permit, or conduct a title search on a property if the bank's involved, real estate sale. Army Corps, DEC, any other regulatory agencies, health departments, they're going to want to discuss with you, new restaurants opening up, or wetlands are being impacted, floodplains, and that type of thing. To be a good listener, you have to just be silent, right? That's what they say. Best you can. Just listen to the other people. Don't talk over them. Have them explain their situation. Some might be excitable, and some people are coming in for a reason. They just received the order to remedy from you, and now they want to confront the issue with you. You have to be prepared for that. Don't think ahead of what the other person is going to say, and don't interrupt. Encourage the speaker to continue. And then basically, if it starts getting escalated, starts escalating out of control, just bring it back down. Don't escalate along with them, and that just makes it worse. So try to be as calm as you can. Some people you just can't communicate with, and I get it. I've been in this a long time, and some people, you just can't, they have their way of thinking and their way of thinking only, whether it's, the constituent or the code person themselves. And you're not going to change that. So you're not psychiatrists, psychologists, so don't try to be. But, first of all, this is an honorable profession. There's nothing wrong with this business. I've been in it a long time. You provide a good service to the community. You should be a resource for builders, architects, designers to come to you with any kind of question. If they look things up together. Answer questions. That people have. Don't just say that's for you to find out or that type of thing. So be on the level. Be honest. Speak for yourself. You're not speaking for anyone else but yourself. Deal with the other person's feelings. And like I said, they might be upset. You just got issued a certificate of violation, code violation, or something like that. Ask, and I would, if I'm discussing anything with people, I usually write a note down. What we're discussing. You don't have to, have it verbatim what they're saying, but I would just take notes of this meeting, especially if it's a little testy. But 95%, 99% of your work will just be interfacing with the constituency, the applicants and the regulatory agencies, and you don't have to be too defensive or anything like that. Be as relaxed as you can. If you don't know the answers, you don't know the answers. Just look them up, say you'll get back to them, and that type of thing. And don't, be sure that if you give any approval of anything, that you have that written down somewhere, that you just said, no, you discussed this with so-and-so, and they're planning to, and I suggested, yep, it's permitted in the district, in the zoning district, and the next step for them would be to make formal application to the planning board for special use permit site plan, whatever the case might be. You have a lot of information to try to disseminate with these applicants. Again, your departments are usually understaffed. You may be overworked. I mean, I don't know the matrix of every place, but so you have that to consider as well. But don't show the constituency your lack of patience, that you're disgruntled, you haven't gotten a raise in 4 years, and that kind of stuff. People don't want to hear that. Certainly don't want to hear about your union problems or anything like that. Keep that to yourself and inside your four walls. Remember, these are your customers. They're coming to you with a reason, purpose, and for the most part, if they're going to be building something new or renovating an existing building, taking something that was off the tax rolls, put it back on, you should be, robust in helping them, because they're going to make your area better. So, they're not the enemy. Just talk to them, respond properly. Media's, I didn't get too involved with too much media stuff. Basically, press releases are always the best thing if you're going to have to deal with anybody. But if they charge you with microphones and whatnot, let's just say you have some real serious issue that you issued a stop work order, and the press is obviously going to want to know what happened over there. Why did these trusses, why did this building collapse? Did we have proper permits? You shouldn't just say no comment, like you're trying to hide something. Just say, if you don't know, I'll get back to you. Yes, we issued stop work order. There has been a failure. The trusses fell. The building, the wall fell down during the heavy winds. Where it's still, our engineers are still reviewing that to find out the cause and origin, or if a big fire or something like that. Use the media portray technical, competence. Basically you could use the media to, send out, we have Fire Safety Month in October, and, you're going to please change your smoke detectors, check your alarms, whatever the case might be. You could even do some public relations stuff with, discussing a different zoning section of the town each week in the paper. Every once a month, do a special on, what does zoning mean? What does floodplain mean? What does, wetlands mean? That kind of stuff. And just, so if the press is gonna deal with you, then, just be prepared for them. Public information, a press release so that is written, and you hand this in or email it, and that's you're not asked. You might be asked an email question, but you're not at a press conference. Is a meeting with the media. You say something. Yes, we had a fire over here on Kings Highway, and several structures were decimated. We're still under review by the fire investigators. We don't know the cause, the origin, or anything at this point. But the building's been cordoned off and it's safe, for the time being. And then they can ask, then it's a press conference, and they will ask you questions. I would prefer the press release where you just say a statement, send it in, let them quote from that statement, and maybe a few quotes on over the phone. But I'm not F. Lee Bailey. I'm not a public speaker to any degree. I don't, and some of you may be, good in debate class, but for the most part, code enforcement stuff doesn't have to be a dog and pony show. It's just the facts, and leave it at that. Dealing with the media, you might want to talk to the town attorney, your town city council, before you get involved with being quoted in the media and so on. They could have some departments, some towns and cities have a policy of a public relations person who does the discussions with the press. Do your homework, be prepared, contacts, names. Those are the, have a clear idea what's going on. Last thing you want to do is get on there and answer questions that well, there was a fire last night over on Belvedere Lane. Is there, do you have any knowledge of that? Has anything been done with that? And then you say, gee, I wasn't aware of that fire over there. May not look too good. So, and what are we going to do after that? Well, I'll get back to you. So, and what's your schedule? Timeline. Again, I wouldn't get too, in my entire career, I did a lot of press releases and a lot of phone conversations with the press, but only one press conference where I was called up by the town council person to just answer a question about, it was a factory with some toxic stuff on it, and we had issued a stop work order. It was in court and all of that, and I just reiterated that it was, it's still under review, and it's in court currently in the Supreme Court. and that was that. So, but you know, the press releases, that type of stuff, and just keep the facts. You know, don't elaborate. Don't. This isn't your time to shine and tell them all about your personal life or your personal, you know, your favorite sports team or anything like that. Let's just be comfortable, be in control, know your facts, just know what's, you know, basically they're going to ask you about this or that, you know, unless it's trying to trap you into something, but I'm not sure that it's too often with a code person. And what kind of clothing? You know, I would wear, if you're dealing with, you know, I would wear a, you know, shirt and tie, or you know, a blouse or whatever that's, you know, more professional than your everyday work clothes. But you know, that's up to you folks. I would always keep things. If I had to deal with the media, I made it where it was where they met in our office. Yeah, I always wanted to be on our turf, so to speak, because it just seemed like it gave more of a you know, professional appearance, and it was on your turf, the town hall, city hall, whatever it might be. And you know, it helps you control the situation. And again, press releases versus the press conference. You know, press release, it really controls the information. You're the one writing it. I would be very clear. Doesn't have to be very long. And then, you know, you submit that. Now, press conferences, again, you'll prepare a short statement. You'll you know, answer questions, listen to their questions. If you don't know the answer, just say, I have to get back to you on that because I don't really, you know, I have to review that, or it's still under review. You know, if you issued a permit in error and you now had to rescind that permit, you then be honest and say, yes, I issued a permit for a 4-story building and only 3 stories was permitted in the zoning district. And at this point, we've rescinded the building permit based on this error that I caused, and it's under, you know, review now by council and the applicant's legal team or whatever. So, but you know, you don't have to admit that you just admit that you did something, you know, in error, but you didn't maliciously do something. If somebody got hurt in your jurisdiction, someone got killed perhaps, before I talk to anybody in the press, I would talk to your town council, city council, and just make sure you know what, you know, at that point, you don't want to be, you may be the subject of an investigation, so you might want to steer clear of that. Public service announcements, you can do this as well. It's a good way to let you know, let the public know that you have, you know, we're working on rezoning such and such a road, or we're looking to, the industrial district is now planning to expand to other areas of the town or city. And it can be simple, and you could write the public service announcements and have someone who's a much better speaker than yourself make the announcements. That's up to you. Be aware of the you know, the live interviews. You know, if they ever say, you know, this is off the record, well, it's not off the record. If they're ambushing you, they have something on you, and you know, they show up and they just you know, you're not prepared for this altercation or interview, and they're gonna maybe say, catch you out in front of your building, your department, going out to your vehicle. So, and then one more question, that's always going to be the zinger. So just be prepared for all that. So, follow your chain of command. If there's someone above you, then talk to them first. Control any rumors. Nip that in the bud. Confirm or deny the rumor. Just say, look, we have no, yes, we issued a permit in error, but it wasn't maliciously done. It was an accident. Nip that in the bud, right? Otherwise, they're going to say, well, if he's on the take, they're paying them under the table. Centralize all the information. Make sure that all your organization speaks with the same information. Right? If you have a bunch of staff people, and they happen to catch them, you all should be, or the elected officials, you really all should be speaking with the same voice. You shouldn't have 4 different answers. So you're the authority on this particular issue when it comes to a building code. So you're the one who will be answering. You would be the authority. They should be going to you and not anyone else. But if someone else says anything, make sure that you all have the same story, not a made-up story, but a factual story. Update it frequently if you're getting more information about something. Then keep them informed. Right? Be preemptive if necessary. It may be in your interest to take the initiative and make an announcement. If you can anticipate a damaging report or attack, show that you are not trying to hide anything. That's, in my opinion, the most important thing. So if we had fatalities at places that buildings that I worked, that were under our jurisdiction. We had OSHA involved, and I tried to be ahead of that story all the time. And that type of stuff goes to the court and whatnot. And then control the site access. You don't want people getting in there, without your, especially if it's cordoned off, property that's cordoned off. 8 ways to, before it happens, to face the crisis. Picture the situation and put it into practice before you need it. Get your facts, or the facts will get you. Right? Be specific and compelling. Be brief to build a rapport. Make unlikely allies before you need them. I would be, fire service, right? Fire chiefs, law enforcement, DEC, Army Corps, regulatory agencies, health department. Make these allies before you actually need them. Be plainly clear. Look to the positive intent, especially when they appear to have none. Be the first to say you're wrong when you are, or if you are. Dealing with the media, basically the deadly sins: do not assume you're out of range. Do not discuss issues unless you have the facts. Don't allow the media to sensationalize. Do not allow personal behavior to detract from the message. Don't try to be funny. It's not a joke. Don't convey false intimacy like you're buddies with these people. Do not speak negatively about anyone. Just keep it to the facts. Don't say, yeah, that guy's a clown and always building without a permit. Way off the mark. And don't speak off the record. Everything you say is on the record. Somebody's going to have a record of it. You're a public official, so that's what it takes. Don't deal with what ifs. Well, if this, that, or the other thing, and then do not offer those personal opinions. No one wants to hear those. No one really cares about any personal opinion. So it's more than just talk. It can be learned. and you can learn a lot from it. They're out there, so be careful. Some are always looking to sensationalize something, and you just have to deal with them as best you can. Records in public service. Legal issues which keep the public informed in the municipality functioning. Records are an important part of your business. Whether you're in private practice or work for a municipality or whatever, you have to have some sort of records. You need to find an inspection report, because you're doing, your time, 3 years are up to go do another inspection of a multiple dwelling or something. So the objective here is to define what is a public record, and identify the laws that discuss the regulations for keeping these records. Most everything is a public record, except maybe the things you put on a post-it, but anything that once they file for a permit basically becomes a public record. On and after the 1st of July 1985, Secretary shall have power to investigate and conduct hearings relative to whether administration enforcement of Uniform Fire Prevention Code complies with the minimum standards pursuant to this subdivision. Basically, program review, record keeping. This is part 1203.3 subparagraph J. So it's a system of records of the feature and activities specified in all these subdivisions, and the fees charged to maintain building permits, construction inspections, stop work orders, C of Os, notification of fire and explosions, procedures regarding unsafe structures and equipment, operating permits, fire safety and property maintenance inspections, procedures for complaints. So this is by statute, you are required to maintain these public records, and they have to be available for public review. So a definition of a public record is any book, paper, map, photograph, micro photograph, or other information on storage devices in any manner, which an entry has been made or is required to be made by law, or which any officer or employee of said bodies has received or is required to receive for filing. A building permit, a site plan, an inspection, a construction inspection, that you're required by law. So they need to be, there needs to be a record of that. You do inspections, so they have to be filed. You issue permits, that has to be there. You answer complaints, again, that's also part of your code requirement. The advantages of a systematic retention and disposition of records ensures that the records are retained as long as they are needed, ensures records are promptly disposed of when no longer needed. It frees up storage space for other records, eliminates staff searching through unneeded records to find something, facilitates preservation of archival historical records. And a short note on the historical records is many drawings and photographs and things like that were collected over the years. So you might find those in your records, and if you do, before you discard them, you don't need them, bring them over to your historical preservation commission or something like that. Another, by the way, another regulatory agency, because if it's a historical commission, they have oversight. If it's an architectural review board, they too have oversight. So there's a lot of, you have to interface with a lot of different hats and organizations, committees and commissions and so on. Public officers law, these are the require the disposition of these records. Local government records may not be disposed of without consent of the Commissioner of Education. Now, I'm not sure why the Consolidated Arts and Cultural Affairs law is the one where this stuff is came from, but it might have something to do with historical records and archival information that was lost, and they wanted to maintain this stuff because it's of value to the state, to the country. To dispose of any public record, you must first obtain a retention and disposition schedule issued by the State Archives Department. It contains minimal legal retention period, different periods for different government agencies. Again, you have to, request your agency, and not, you're not working for the health department or the state ed department. You're working for the building department. So a typical schedule for building construction stuff is the master summary records, permanent housing or building inspection records, 6 years after the building no longer exists, but in no case less than 21 years. Single family home exception, tax pool, 6 years after entry in the record. These may vary. I'm not certain, but certainly if you take over a position, don't go in and just say, I need more room, so I'm going to start heaving out some boxes of files. Make sure you get some sort of documentation to do so, because you will now be subject to scrutiny that you threw away files that you weren't allowed to do. So specs, this construction specs 6 years after denial of or completion of the work. Building condemnation, demolition files, permanent. Again, that comes to things where you have lead and asbestos abatement records and so on that should be there permanently in that file. Contractor's liability insurance, 6 years after the denial or expiration of the permit. So they want to make sure that there's liability still there, right? And there's a reason for that. 6 years permit granted 6 years after the building no longer exists. Permit denied 6 years after the final. Oh, the slides are not advancing. Oh, I'm sorry. Okay. 1 minute here. Okay, so the advantage of the retention is, again, ensures the record is kept, frees up storage. A lot of this we already went over. So you created them, you have to live with them. So, make sure that you get with the department to see where you can put them. Many of the departments can, find a space in the storage facilities or a space in the highway garage and that type of thing. All right, so now FOIL, Freedom of Information Law, provides for the rights of access to records of government decision policies. This is integral to the idea of democratic government. It's a concept that the public has a right to know how its government operates. In New York State, Freedom of Information Law and Open Meetings Law are the mechanisms to institute and to ensure the concept is implemented. So, you want to know what your elected officials are doing. They shouldn't be making decisions with quorums or behind closed doors or in the bar room or at a dinner party. And they should not be spending any of the town or the city or the village's money without, without knowing where that's going. So covers all state and local government, state agencies, public corporations and authorities like the Thruway Authority, any governmental entity performing governmental functions. This does not, you cannot foil the freedom of information at IBM or at Global Foundries. These are private entities, right? GE, General Electric. These are private entities. You have no authority to foil any of that. If there's an issue with one of these big firms, then you would need an attorney to file an action, and if you need to get information from that, it would be under the discovery issues regarding courts of law. This is only pertaining to any government entity. That means the DEC, the Army Corps, even the U.S. military, everything that's done with federal funding, state and local funding is subject to the FOIL statutes. So most records are obtainable. So what if someone wants to see these records? They ask, you show them, and whatever the office policy is in your department or your village or town, you have a policy where they go through the FOIL public records administrator for your town, which might be the town clerk or one of the deputies or whoever. And then you request in writing that they're what they're requesting. They should be specific. I want all the data and information on the building permits and the inspection records for the Walmart building that's going up on the edge of town. And then how do you deny? Can you deny that? And the answer is some of it can be. We'll see. To deny the records must trigger one of the following. The release is specifically exempted by other statutes. That could mean something, a legal entity there. Release would result in unwarranted invasion of privacy, right? That's something that the courts have upheld. Release would impair contract awards or collective bargaining. You wouldn't want to give away trade secrets and that type of thing. Would it affect the trade secrets and maintain regulatory enterprise? So, if it happens to be the formula for some chemistry additive, chemical additive to something, that wouldn't be foilable. But again, anything that they're requesting from the town or village should really be pretty fairly simple and straightforward. You don't have to you don't have to like hold these cards close to your chest and keep things. You don't want to make it look like you're hiding anything. So for the most part, with building records, that's mostly all allowable. And then release would also, affect items compiled for law enforcement, right? So you might have some people involved. It could be, an informant of some type or something like that. Release would endanger the life or safety of something. Provide examination questions. Obviously, can't foil for that. Provide computer access codes. Naturally, we want them to know that. Include advisory memos that do not affect policy. Intra-agency records that are not deniable. Statistical instructions to staff that affect policy. Agency memos that affect policy determination. If these are just post-its, that, like I said, somebody's writing one person to the other, then these, that's not affecting policy and staff. And so how do they get these? Each agency must maintain subject matter list, file the categories. Each agency must adopt standards based upon general regulations issued by the Committee on Open Government. Each agency must have a records access officer. Again, that could be the town clerk or one of the deputies. Request should be reasonably describe the records in which they're being sought, the date, time, file, designation, etc. And they have 5 business days to respond, approval or denial. And if there's any fees related to that, 25 cents a page or whatever the case might be. Denial of the access or appeal, and appeal must be within 30 days of the denial. So if the agency sends out a note says we can't give you this, it's blah, blah, blah. The agency head governing body appeals. The officer has 10 business days to provide access or fully explain in writing the reasons for denial. Copies of all appeals and determinations must be forwarded to the Committee on Open Government, a monitoring mechanism, which really doesn't happen often. The committee has the right to intercede when a denial may be improper. Judicial review of financial agency denial by means of a proceeding initiated under Article 78, which is known as an Article 78 proceeding. Practice law is the last option. Agency carries the burden of proof. The the Article 78 proceeding, by the way, is something that if let's just say that there's someone in your town or municipality, you issue a permit, they say we're not allowed, that's in violation. They go to their local zoning board of appeals, and the zoning board of appeals upholds your decision that the use is proper in this district, and you issued a permit, accordingly. At that point, the plaintiff would have an opportunity to file an Article 78 proceeding, naming the zoning board of appeals and the town of whatever the town is, and that would go to the Supreme Court, the county Supreme Court, and they would hear that case in one way or the other. And then if they weren't satisfied, they can go to the appellate division, which is in Albany. And at that point, they could go to the U.S. Supreme Court, but that's doubtful. But so that's their option. If they don't get, they feel they've been wronged, they can file an Article 78 proceeding. And again, that's also to gain access to those records that they've been denied, if they feel they should have. So here's something that you want to remember. The the opens meeting law is simply known as the sunshine law. That all that means is that they, they're shining the sun on backroom deals. So it's not the official name. The official name is open meeting law, and I believe there might be an exam test question on that. But just remember, it's the open meetings law. An official convening of a public body for purposes of conducting business. This became effective in '79. And if there's a quorum of a group, if it's 5 people, a 5-member board, and there's 3 people, it's a quorum that constitutes a meeting, and they should not be doing that together. I assume if they all attended a graduation ceremony and they're in the audience, that's one thing. But if they're congregating around making some sort of backroom deals or whatever, not allowed. Any official convening of a public body for purposes of conducting public business must be done in the public forum. We'll explain some of that. Closed or executive session. It's a portion of an open meeting where they will close that part of the public meeting to convene for an executive session, and the executive session can only be must be carried out by a majority of the members. It can only be carried out in the following 8 circumstances. That's matters which imperil the public safety if disclosed, right? We wouldn't want anybody to know that. They need to discuss that. Matters which may disclose the identity or agency or informant, information relating to investigation or prosecution of criminal offense. That makes sense. Matters regarding pending current litigation. We understand that. Collective bargaining, right? That's the unions, negotiations and so on. Personnel or personal records, right? They have some issue going on with one of the employees or whatever. Preparation, grading, or administration of exams. You certainly shouldn't, that should be able to be put, in executive session. An acquisition, sale of real estate or securities only when publicity would substantially affect the value. So if they get wind that the town or the village or the city or the county is about to purchase 50 acres over here for a landfill or something, they wouldn't want that to get out in case that that price increased exponentially. So during a closed session, a public body can never vote to appropriate public monies during a closed session. They cannot vote to approve any monies in a closed session. Okay, so basically the summary is, public records, they're the public property. And they have to be kept as such. Retention and disposition can only be done under the requirements and statute. Public officers law, freedom of information, and the opens meeting law. So, okay, so if anybody has any questions, we're going to end for today. And if you have any questions, just send me a text, email, or you can call it or send it in the chat. Other than that, I'll see you all next Thursday.
Have a great weekend.
Okay, you too.
Thank you so much.
Thank you.